What is partition? Partition is redistribution or adjustment of pre-existing rights among co-owners and co-partners resulting in division of land and other properties held by them into different proportions and thereof delivered to each of the shareholders according to their proportion and shareholding, thus converting the co-ownership and co-partnership into individual ownership. Now we come to what is HUF. I'm sure everybody of you know of it, but under Hindu law, HUF, that is a Hindu undivided family, is defined as a consisting of all persons who are linearly descended from a common ancestor, along with their wives and unmarried daughters. So Hindu undivided family, the term HUF, is formed under Section 231 of the Income Tax Act and is treated as a special legal entity. Now, what are the major acts governing the partition law? We have the Partition Act, the Code of Civil Procedure Law, and the Transfer of Property Act. Now, Section 54 of the Code of Civil Procedure mentions that the partition of an estate or a separation of a share where a decree is for a partition of an undivided estate assessed for payment of revenue by the government. So this property has to be assessed as per property tax, etc., has to be paid, or for a separate possession of a share of such an estate, the partition of the estate or the separation of the share shall be made by the collector or the gazetted officer notified by him on that behalf, or the separate possession of shares of such estate. Now, under Order 20, Rule 18 of the CPC, the decree in suit for partition of a property or a separate possession of a share is where the court passes a decree of partition of a property or separate possession of share therein, then if and insofar as the decree relates to an estate assessed of the payment of revenue. So again, this has to be a taxable property, but shall direct such partition or separation to be made by the collector or gazetted subordinate of the collector deputed, as I read out as per Section 54. And insofar as such decree relates to any immovable property or a movable property, the court may, if the partition or a separation cannot conveniently be made without further inquiry, pass a preliminary decree for declaring the rights of several parties interested in property and giving such further direction as may be required. Thus, in partition suit, the court will go into this aspect. Thereafter, the court might pass a preliminary decree depending upon the case. When the preliminary decree is passed, the next step is that under Order 26, Rule 13, the court may appoint a commissioner, okay, to such person or such person as it may deem fit to be able to record and access the rights of the litigants. Now, under Order 26, Rule 14, Procedure of Commissioner, the commissioner shall, after such inquiry as may be necessary, divide the property into as many shares as may be directed by the order of the court. So a preliminary decree is required. Thereafter, under the order of the court, the commissioner is appointed who will be dividing the property as per the order and shall allot such shares to the parties as per the order. The commissioner shall then prepare a report and sign the same and submit it to the court. In the event if the commissioner is not in a position to divide the property in metes and bounds, which I'll come in later, and then in such an event, or there is a difficulty for the commissioner to be able to divide this property, then he shall submit such an order or such a report to the court, and accordingly the court will take a decision. Now we come to Income Tax Act. Under Income Tax Act, Section 171 of the Income Tax Act, the assessment of HUF, which is very important because many times we come across where we don't know whether HUF is formed in those olden days, but the only way to find is to find whether the assessment of HUF has taken place. And HUF is recognized as a separate assessable entity under the Act, as I mentioned above. But there are two conditions to be fulfilled. One, there should be a co-partnership. In this connection, it is worthwhile to mention that once a joint family income is assessed, as that of HUF, it continues to be assessed as such in a subsequent assessment years till partition is claimed by the co-partners. So therefore, the HUF is in existence. The presumption of it is that you are continuously paying the tax and the income tax is assessing the returns, and that's where the HUF is still in existence, unless and until you demand partition. And the second is there should be a joint family property which consists of an ancestral property acquired with the aid of the ancestral property and property transferred to its members. So thus the two criteria is that the income has to be continuously assessed of the HUF and HUF has to have a property in it. Now, I'm sure a lot of you might question that how do you form an HUF or what you do with the HUF or how do you call this as an HUF? So I'll just give a small little example. Supposing it's a nuclear family of 4 people, father, mother, daughter, and a son. In that scenario, once the father forms an HUF, now that HUF property, he might buy his house or he might buy any number of properties in this particular HUF. In that HUF, each of them will be the co-partners. The father will be the karta, the mother will be the co-partner, the son and the daughters also will be the co-partners. So that's how, once I continue with my presentation further, you will be able to understand how the division takes place. Now I'll go back. The partition of HUF. Partition means again division of property. Where the property is capable of admitting physical division, shares of each member is determined by making a physical division of property. On the other hand, where the property is not capable of physical division, partition shall be in division of the property as the court may deem fit. Now, through partition, only co-partners can claim for partition. Okay, that is the son, and also if the son is in the womb of the mother, or the mother gets for the partition only if the father has passed away. Now, how does the assessment after partition takes place? Once the income of the joint family is assessed as an income of HUF, this is very important on the point of the taxation point of HUF is concerned. It will continue to be assessed as such until one or more co-partners claim partition. Such claim must be made before the relevant assessment year, as I read out earlier. The assessing officer on the receipt of such claim may make an inquiry after giving due notice to the members to record a finding whether there was a partition, and if not, if so, then the date of partition. So from the income tax point of view also, the date of partition makes a difference because that's where you say whether the partition had taken place or not. This is where you have HUFs which are running for years together and then suddenly there is a partition. So to prove that also in court, you might have to go back in time and see when was the last time the tax was paid and when was the last time the assessing officer had issued any notice to check if there is a partition or not. Now, the partition can be of 2 types. One is total partition and one is with regards to partial partition. Under the Hindu law, the HUF is entitled to effect a partition which may be total or partial. Now, total partition is where the HUF undergoes, the entire family undergoes this partition. All the joint family properties are divided amongst 8 or 10 or 20, how many ever members are there in the HUF. That's the whole, and the HUF ceases to exist. So that's where the whole partition takes place. Whereas in case of partial partition, a partial partition on the other hand may be partial as regards to the persons constituting the joint family or as regards to properties belonging to a joint family or both. In a partial partition, as regards to the person or one or more co-partners may separate from the other and remaining co-partners may continue the joint Hindu family. So therefore, what happens is that supposing there might be a case where there are 20-30 properties, but 2 or 3 co-partners might want a division or might ask for a partition. Now that is only limited to the aspect of 2 properties. So to that aspect, the whole partition only with regards to the partial partition takes place, total partition does not take place. Now, effect of partial partition under the Income Tax Act. After the enactment of 171, the partial partition is not recognized by this act. The provisions of section 171(9) is applicable on satisfaction of 2 conditions. So if these 2 conditions are satisfied, then only the partial partition should have taken place after 31st December 1978. And secondly, such partition must have taken place in an HUF which was HUF assessed before by the income tax authority. If the above two conditions are satisfied, such family will be continued to be assessed as if no such partial partition is taken place, and the property or source of income will be deemed to be so belonging to HUF, and no member will be deemed to be separated. Now, how does a partition take place? There are three types in which the partition can take place. One is partition by mutual agreement, one is partition by court, and partition through will or probate. Now, partition by mutual agreement. This can be further divided into two categories. One is partition deed, that once you draft a partition deed and the same needs to be registered, all the properties are divided. The second is by family settlement deed, where alternatively the families, they all decide together that this is how we want to divide the assets. There could be a possibility in the family settlement deed where you either divide it at this point in time, or it is a recording of the family arrangement that after some incident or maybe after the death of the father or the mother, this is how it needs to be divided. So the family arrangement could be done in that manner, and the partition deed is where this partition deed will be the end of HUF, and you have to submit this partition deed even to the income tax authority to determine the date of partition. Now, when it comes to partition by court, I will go further with that. Under Section 2 of the Partition Act, power to court to order sale instead of division. The court has the power to order for sale. Whenever in any suit for partition in which, if instituted prior to the commencement of this act, a decree of partition might have been made, it appears to the court that by reasons of nature of the property to which the suit relates, or by the number of shareholders therein, or by any other special circumstances, the division of property cannot reasonably or conveniently be made, and that a sale of the property is just and equitable, then the court, if it thinks fit, on request of any of the shareholders individually or collectively to extend one or more, direct a sale or distribution of proceeds. Now, in this scenario, what happens that if you have, supposing a 2 BHK house, now that 2 BHK house, if it has to be divided, it becomes difficult to divide because you definitely by meets and bounds can't divide one bathroom, one kitchen at one side and one room on the other side. So that division could be difficult. In that scenario, either the court orders the sale of this entire house and both the two or three, how many ever co-partners or the legatees are, they can take a share, or it might say that, okay, one of you might take the share of the other person and purchase the share of the other person. So it depends on case-to-case basis what court can direct. Now, there could be a process of a bidding also. Now, this procedure of a bidding takes place when? Let's see. If in any case in which the court is requested under the last foregoing section to direct a sale, any other shareholders applies for a leave to buy at a valuation, like I said before, at a valuation, the share or shares of the property of the party or parties asking for a sale, the court shall order a valuation of the shares first, as it may think, and thereafter, if two or more shareholders apply to leave to buy, the court shall order for the sale of property through the highest bidding process. So if there are two or three shareholders who are shareholders in terms of co-partners are willing to purchase a particular property, could be a bungalow, could be a haveli, could be anything. In that scenario, the highest bidder will get the property. Now we come to court can partition a part of it and sell the other. So earlier we saw where the court is only giving you the order to sell. Here in the scenario, typically the case might be that a part of the property can be divided, but the remaining could be sold. So in that scenario, in Section 9 of the Partition Act, saving of the power of the order, partly partition and partly sale, in any suit for the partition, the court may, if it thinks fit, make a decree of a partition of a part of the property to which the suit relates and sell the remainder of it. So it could be, supposing the partition is of some 5 flats and 2 bungalows or row houses. In that scenario, maybe if there are 8 or 10 contenders, each one might ask for one depending on the valuation. If the court feels that the valuations are not coming correctly to give everybody equally, then in that scenario, court might ask to sell certain part of the assets. Whatever the money comes, that can be divided between the co-partners, and the balance property which can be divided between them will be divided in meets and bounds. Now, classification of property and kinds of properties that can be partitioned. So property is classified in two parts. One is joint family property, that is the ancestral property, and self-acquired property. Now, ancestral property may be defined as the property which a man inherits from any of their three immediate male ancestors, that is father, grandfather, great-grandfather. Income from ancestral property held by following families is taxable as income under HUF. A family of a widow mother and sons may be a minor or major. A family of husband and wife having no child. A family of two widows of deceased brother. Family of two or more brothers. Family of uncle and nephew. Family of mother, son, son's wife. Family of male and his late brother's wife. These are the scenarios where HUF can be formed. I had given you one is where there's a nuclear family between father, wife, one son and one daughter. Property obtained by the daughter from the joint family property would be her absolute property, and any income therefrom is chargeable to tax in her hands in an individual status only, and this will only apply to any legal heir obtaining property in the capacity of her descendant. Now, property jointly acquired by joint members. So there could be basically the property also could be not only by immediate nuclear families, could be two brothers coming in together with their own families buying a huge property. There could be a property which could be probably the full family has bought in funds and kept it in a joint fund or joint undivided funds they have created, and from that family fund they have purchased a property. Again, that also forms a part of a joint Hindu family. Now, what is self-acquired property? There is a lot of division and classification before the enactment under the Hindu law. So let me just go back in time and tell you about a little bit about Mitakshara and Dayabaga law. I won't take much time on this. In Mitakshara, school divides the property in two categories. Now, Mitakshara law is basically practiced almost all over India, and Dayabaga is practiced more on the West Bengal, Assam side. Mitakshara law divides the property in two categories. One is obstructed property and the other one is unobstructed property. Further, after the enactment of Hindu law and decline of both the principal schools, the property is now divided between joint family and separate or a self-acquired family property. So before the Hindu law, this is how they used to divide. Again, your obstructed property is where the property to which the right accrues not by the birth but by passing of the final owner of the property. So say for example, if this property were owned by three people, after the death of the last person owning the property, then the property would have been devolved upon. Now, that is called an obstructed, since the accrual of the right of it is obstructed by the existence of a final owner. Hence, the property devolving on the parents, brothers, nephews, uncles, etc. upon the passing of the last owner is unobstructed. These relatives are not vested in treat by birth, but only when the death of the last owner. In this way, any property acquired by a male Hindu for relations from other than father, father's father, etc., would be called as obstructed heritage. So basically, your ancestral property, here they termed it as obstructed heritage. The owner of this property holds the property as separate and absolute, and there is no chance of combining this property. Now, in today's time, the self-acquired property, there is a recent Delhi High Court judgment also, which says that in a self-acquired property by the father, the son cannot demand partition. So that is one of the judgments which is there. Now let's go back to unobstructed property, which is HUF property that we used to call. The property in which the individual secures and is intrigued by birth is called unobstructed property. So in obstructed property is where the last owner expires, then you get the right. Here, from by birth, you get the right, which is the new age, or now you call it as HUF. Since the accrual of the right of it isn't obstructed by the presence of the owner. Hence, the property is inherited by the Hindu from the father, grandfather, and great grandfather in an unobstructed manner. Now, according to the Dayabhaga school, all heritages are obstructed. No person takes an interest by the birth in the property of any other person. The Dayabhaga school does not recognize the principle of survivorship. It recognizes only the right of succession, and this right naturally accrues for the first time upon the death of the owner of the property. Not whether it's the first or the last, it's on the death of the owner. Now, who can acquire ancestral property? Now, in this case, Anshur Singh versus Harpal Kaul, 2020 14 SCC 436. It is held by the Supreme Court that under Mitakshara law, whenever a male ancestor inherits any property from any of his paternal ancestors up to 3 degrees above him, then his male legal heirs up to 3 degrees below him would get right as a kopasna. In other words, his father, from him, his father, his grandfather, 3 degrees, and below him, his son, his grandson, his great grandson. So these are the 3 degrees above him and 3 degrees below him. After the amendment and enforcement of Hindu Succession Act in 2005, women have also allowed to enjoy the self-acquired property or ancestral property with equal rights, but this right of ancestral property was not earlier provided to women. So I will, in my presentation, I'll come in later with regards to the women's right towards the ancestral property is concerned. Now we go on illustration on self-acquired property. Any property that is acquired by a person himself, either by way of his own resource or by way of division of an ancestral property. Now, in VD Dhananwati versus Commission of Income Tax 1968 AIR 682, it's on the screen. It was held that the general doctrine of Hindu law is that the property acquired by the Karta, senior-most member or male member of the joint Hindu family, or a co-pasna, that is any individual who is born in an HUF, becomes a co-pasna by birth, with the aid or assistance of joint family assets, is impressed with the character of joint family property. So if Karta buys it with the family assets, it becomes a joint family property. To put it differently, it is essential feature of a self-acquired property that it should have been acquired without assistance or aid of a joint family property. It is therefore clear that before an acquisition of any claim of a separate property, it must be shown that it is made out or without any assistance. So therefore, the person at the time when there is a challenge whether this property is a joint family property or a self-acquired property, the person has to prove that it is a self-acquired property, has to show that he has purchased this property with his own funds and it is not being taken by any family funds or any of that sort. So that also could be one of the challenges where when you do a partition suit, somebody might come up and say this was actually an ancestral property and not a self-acquired property, but that's where you prove that it is not a it is a self-acquired property with the details of showing the mode of payments to be done by them, which is through their own account. Now, properties which are not subject to partition. Now, this is impatriable estates, property which descends from one person to another because of some custom like Raj, municipality. These were the in old days. Dwelling houses. Now, this is a very important part. In ancient times, the Smritikars believed that dwelling house cannot be partitioned. But in modern view, they don't believe that. But the partition of dwelling house will be decreed if insisted by court. But the court will try the dwelling house stays with one or more co-pasnas. But if no agreement is made amongst them, then the dwelling house will be sold and all the sale proceeds of the sale will be divided among the co-pasnas. Now, this particular you can find in Akul Chandra Sandhunu Khan versus Ajit Kumar Sandhu Khan, AIR 2004, Calcutta 170. Now, Section 44 of the Transfer of Property Act states that where the transferee of a share of a dwelling house belonging to an undivided family is not a member of a family, that is an outsider. That means nothing in this section shall deem to entitle an outsider a joint possession or a partition. So the outsider cannot call for a partition of a dwelling house. It's only when the co-partners ask for it. Then you have family shrines, temples, idols. Then property indivisible by its nature. So say, for example, it's an art piece, or it's a jewelry, or it could be a furniture, fixtures, any art deco piece. Those cannot be divided. Then legislative prohibition. Now, if it is prohibited by the law that you cannot divide this property, then this also properties cannot be divided. Now we come to the next part, that is what is partition by metes and bounds. Like how I was talking to you earlier, that the property can be divided by metes and bounds. That is probably if there is a, 5 bedroom flat, or it could be a 6 bedroom flat, maybe that may could be divided, or there could be a possibility of two flats which are combined. The two flats can be divided in, first is kept as one and then it is divided into two. So in that scenario, also by metes and bounds, the court might order both flats, the common wall to be again brought up, and two flats can be divided. So that's where your metes and bounds come in. Now, metes and bounds is basically the territorial limits of the real property as measured by distance, angles, and from designed landmarks and relation to adjoining properties. It means a physical division of the property. In old Hindu law, the division of metes and bounds was in two parts. One was Putra Bhaga and one was Patni Bhaga. Now, Putra Bhaga means a division of property is done by seeing the member of the by the number of members of the sons. So that is Putra Bhaga. So if they had 5 sons, it will be divided in 5 parts. And Patni Bhaga is where the division of property was done according to the number of wives. So if they have 3 wives, 4 wives, accordingly it was divided. However, now the Patni Bhaga concept is no more applicable, and it's pretty absolute. Now, in partition by metes and bounds, the shares are allotted to co-partners on the basis of division between father and son. So now this is very important to know that how the partition will be divided, because right now we are only taking a simple example of an HUF between a father, one son, or maybe let's take an example of an HUF between father, wife, and 2 sons. In that scenario, it can be divided, everything can be divided between the 4 of them. That is an easy thing. But when there is a little bit on a complex side where there are 2 uncles involved or 3 uncles involved, and then the partition takes place, then how does the court divide these, or how does the metes and bounds take place? One is division is by between father and son, as I mentioned before. One is between the division between the 2 sons or 3 sons. Third is division takes place among the branch. Now, division between the branch is where, supposing there are 2 uncles, the 2 brothers having their own families, individual families, the division will not be between how many sons one family has and how many sons or daughters the other family has. It will be between the 2 families. So there are 2 branches. All right. And doctrine of representation. Now, doctrine of representation states that if during the lifetime of an ancestor, any of his or her legal heirs die, but the latter heirs still survive, then such heirs shall be entitled to share or in the property as they shall be representing their immediate generation. So, for example, if there are 2 branches, as I said, 2 brothers, if one brother passes away, but the other family members of that brother will be representing that particular deceased brother, and they can ask for partition. Now, who can challenge the partition deed? Every adult co-partner. Every adult co-partner is entitled to sue for partition and is entitled to have a share on partition. No other person shall have such rights. Prior to Hindu Succession Amendment Act, even females had no right, but now even they have the right. This amending act has made the daughter a co-partner in her own rights, and therefore she is also now entitled to demand partition. The next is, till when can a partition deed be challenged? Now, in the limitation aspect, if you see, the Article 110 also says that by a person excluded. Now, if the person is excluded from a joint Hindu family, he can enforce his right within 12 years from the exclusion becomes known to the plaintiff, or as per Article 65 of the Limitation Act, the time period is from the date of filing the partition suit is 12 years. That is from the date the possession of the defendant becomes adverse to the plaintiff. Now, the next is, should partition be registered? Now, see, a lot of times there is a debate whether the family arrangements need to be registered. See, in this scenario, there are a lot of different judgments which have been passed where the family arrangement needs to be registered or not. partition deed needs to be registered or not. If you see the partition deed of the HUF, where the HUF comes to an end, there is a transfer which is happening of the property at that point in time where the partition is to be done. In that scenario, the partition deed needs to be registered. In the case of family arrangements also, if the family arrangements are taking place at this point in time and the transfer is happening at this point in time, then in that scenario also the family arrangement has to be registered. Memorandum of recording family arrangement is that even on an eventuality. So say many times now families, to avoid future disputes or anything of that sort, they try to have record of family arrangement where in case of the death of both parents, the property will be then devolved at that point in time. So it's future in time. Right now, it is not, there is no transfer. So in that scenario, you can not, memorandum of recording of family arrangement is not necessary to be registered. But when there is an immediate transfer, then yes, you have to register it and pay appropriate stamp duty. Now, what is a verbal partition? Okay, many times people say that, oh, his intention was this, or oh, they always had this intention and they always wanted to give, etc. to me. Now, this is where we come on. What is a verbal partition? Now, under the laws governing inheritance of among Hindus, Jains, Buddhists, Sikhs, and class 1 heir of property can enter into a verbal memorandum of family arrangement, as I mentioned, and divide the property on mutual agreeable terms. Since this oral arrangement has been reached without using the partition deed as an instrument, the need of transaction needs to be avoided. However, in Nitin Jain versus Anuj Jain and others, the same is on the screen, a division bench of Delhi High Court has held that no stamp duty is payable in case of verbal division of property. It is legally permissible to arrive at an oral family settlement dividing, partitioning the properties and thereafter record a memorandum in writing, whereby the existing joint owners, for the sake of posterity, records that the property has been already partitioned or divided. Courts have recognized oral partitions in the cases of joint families, and oral partition is not an instrument of partition as contemplated under 2.5 of the 215 of the Stamp Act. Therefore, as it is not an instrument, no stamp duty is to be paid on oral partition. However, in the absence of a partition deed, the shares of the co-owners remain undivided in this kind of arrangement. This also means that they are not free to sell, gift, or transfer their shares. So, to avoid the ambiguity and to get the things sorted at this point in time, it is advisable at times to have a partition deed registered so that later on there is no problem, even in terms of taxation is concerned or in terms of your family disputes later on is concerned. So this is one of the steps to avoid future disputes. Now let's go to an interesting topic on persons who are entitled to demand partition of Hindu joint family. Now, who are entitled to? Their sons and grandsons, after-born sons, illegitimate sons, widows, adopted sons, minor co-partners, alignee, and female sharers. Friends, we have already put the judgments which are required on the screen, so you can take down the judgments while I'll be reading a bit of it of the judgments right now. The sons and grandsons, under the Mitakshara law, the right of son, grandson, and a great-grandson, as well as every other adult member of the co-partner, can demand a partition even against the consent of the others. Now, the Supreme Court has held that the suit for partition and separate possession of ancestral property by one of the co-partners is maintainable even if the father is joint and with his brother and is not aiding or willing to or consenting to the partition. The Delhi High Court also has clearly maintained that a son can demand a partition during the lifetime of his father without any hindrance. Now, this situation is where it is a HUF property, not where it's a self-acquired property. All right, so I'm just clearing that confusion if there is any. After-born sons. After-born sons can be classified into two heads. One is sons born Firstly, those born as well as begotten after the partition, and secondly, those born after partition but begotten before it. A son in his mother's womb is treated in law in existence and is entitled to reopen partition to receive his share equal to that of his brother. So we saw earlier also in our presentation that an unborn child has a right to partition. In case of a son born as well as begotten after partition, if his father has taken a share for himself and separated from the other sons, then after born son is entitled to his father's share only at the time of partition, and also his separate property to the exclusion of separated sons, and is not entitled to reopen partition. So therefore, if the son is born, if the son is begotten and born after the partition has taken place, then whatever his father has got, he will have right in that properties. And whatever later on with regards to his other brothers are concerned, he will have the right, but he cannot reopen the partition. Now, illegitimate son. An illegitimate son among three upper classes does not have any vested interest in the property, therefore cannot demand a partition, although he is entitled to maintenance out of his father's estate. But now this has been changed by Madras and Allahabad High Court, and have held that illegitimate son has the right as that of the other as the regular son. However, obviously it has to be proved. The Bombay High Court has held that the share of an illegitimate son is half of what he could have got had he been a legitimate son. And according to others, his share is half of that of a legitimate son. The Madras High Court in the case has held that after the institution of partition suit, the father can still fix the share of illegitimate sons, and he can still exercise the right according to his discretion as long as the partition has not become final. This is again now in Apex Court has held, that is Genia Kiotin versus Kumar Sharam 2003 1 SCC 730. The Apex Court has taken a view that the children born out of void marriage were entitled to the claim inheritance of the ancestral property and were entitled to claim a share only in the self-acquired property of their father. Thus, illegitimate children also have full rights as that of a legitimate children is concerned. Now we come to widows. Widows, though not a co-partner under Mithakshara law, is entitled to obtain a share when the property is divided between the co-partners. Now, adopted son. An adopted son, like a natural son, would be entitled to demand a partition at any time after the adoption. But where a son has been adopted by parents and a natural son is begotten subsequently, although the adopted son was to be treated at par with the wife and the natural son, yet the quantum of his shares in joint property will be differed as per different schools. But however, now the law also looks at the adopted son just as the way it is a natural son is concerned. Now we come to minors. A minor co-partner is also entitled to effect a partition in case the joint status does not remain a beneficial to his interest. He cannot file a suit himself, but any other person on his behalf can file such a suit. So in that scenario, if he's a minor, he can have his guardian filing a suit on his behalf. His minority or the minority of other members of the family would not be a hindrance to that effect. Now, suit by a minor. The Hindu law makes no distinction between a minor and a major co-partner as far as there is a rights of joint properties are concerned. A minor's rights at partition are precisely those of that of the major. Accordingly to Gujarat High Court in Bankle Lal versus Babu Bhai, where any co-partner is minor, he is still entitled to get partition from the joint family property. If the minor has got any complaint, he can re-agitate the entire partition on the ground that it is not equitable or fraudulent. So the minors have that right. Now comes to alignee. An alignee is a co-partner's interest. If such an alienation is valid, has a right to demand partition. In Srimati Kailashpati Devi versus Bhunbhaneshwari Devi, the Supreme Court has held that the purchaser of a joint family property from a member of a joint family may have the right to file general suit for partition against the members of the joint family, and that may be the proper remedy for him to adopt and effectuate his purchase. An execution purchase member interest and the purchaser of the same for a value in Bombay and Madras is entitled to demand partition in rights of that member only. Now, female sharers. The term female sharers include three types of females: wife, widowed mother, paternal grandmother. They cannot demand partition. However, the right to share when property is divided, where the suit is dismissed, mother cannot demand partition. But after passing of Hindu Succession Act, they have the right to demand partition. After a marriage, a daughter ceases to be a member of the paternal HUF, but will continue to be a co-partner. So she is entitled to ask for partition of the HUF property and become the karta of the HUF in case that she happens to be the eldest. Even in case of married daughter who has died, her children are entitled to the shares that she would have received if she was alive on the date of partition. In case none of the children are alive on the day of partition, the grandchildren will be entitled to shares that the daughter would have received for partition. However, a daughter cannot gift a share in HUF property while she is alive, and she can give away the share in HUF property by way of will. If she dies without leaving a will, her share in the joint property will not devolve on other members of HUF but will pass on to her legal heirs. Now we come to the next part, is where you have the renunciation of partition deed. Now this is reunion after partition. Conditions for reunification is the partition is essential condition for reunion shall not take place if there is no intention of the parties to reunite. So everybody has to reunite. There has to be a partition. Takes place only if the person has separated with his father, brother, paternal uncle, but not with anyone else, and must be unilateral. That is, consent of each and every person who is a co-partner is required. Must be a property involved in union. So basically, you cannot have now all the family members are again coming together and you form again a new family arrangement and you renounce the whole partition. But in that scenario, a property has to be involved. Then only you can do the needful. And a minor cannot initiate reunion. It can only possibly happen when he gains majority. These are the landmark judgments on reunion, which I just discussed before, and on daughters having equal rights. Now, our daughters having equal rights, in January 22, I'm sure a lot of you all are aware of this. The Apex Court, through its decision in aforesaid case, held that a self-acquired property of a Hindu male dying intestate would devolve by inheritance and not by succession. The daughter is entitled to inherit such property as well as property obtained through partition of a co-partner or a family property. It was further held that upon her death, if she dies intestate, then the ancestral property devolved on her from the father would be bestowed upon her father's heirs, but the property devolved on her from a husband's side would be devolved onto her husband's heirs if she dies without the son or without any issue. This right is also asserted now under Section 6 of the Hindu Succession Act.
I have a question regarding the purchase of an ancestral property. What
Yes.
care should be taken while purchasing of an ancestral property, just in case a legal heir he is a minor and
Hmm.
if he claims to the property after he becomes a major? In that case, what should the innocent purchaser do?
So in that scenario, what I advise is you can probably have a guardian appointed, and the guardian will need to take the orders of the court, and thereafter you can go ahead with purchasing of the property.
Okay, so
But make sure that the consent of all the members are taken prior to you purchasing the property, because anyone can later on challenge this.
yeah, but you mean to say if the court order is taken with regarding to the guardian and all those things,
Because the
in
court
that
will see, the point is that when the court will go into the entire transaction, they will see that the minor by any way is not getting, the minor share is not getting hampered by in any manner. And thereafter, the court will come to the conclusion whether they'll allow this sale or not. It is a little time drawn process, but that in the court's order, it is better.
Okay, but can the minor say upon becoming a major that I have no intention of selling this, irrespective of
No,
whatever
because there
price?
is a court's order. Now they can't be challenging the court's order unless and until the minor comes to know that you have fraudulently obtained the property, even not telling the court certain things which the court ought to have known. So in that scenario, they can.
Okay, so in case there is no, it is better to go to the court and have an order with regards
Yes,
to the minors.
yes.
Madam, I think practice in family courts is different from other courts because here the litigants are related, related to one another, and there may be affection. So, what is your experience? Are the proceedings necessarily adversarial, or there are more chances of compromise among family members?
It really depends on the case, and it depends on how the parties are, because see, a lot of these are family issues. It stems from it could be an ego issue, it could be anything. Yes, maybe now or maybe later, there are a lot of suits which get settled, but yeah, there are a lot of suits which actually the final order is being passed and then they challenge it and they go to Supreme Court. So it definitely depends on the parties, to be very honest, on how much they are proactive or how much they would want to litigate.
Ma'am, there's one question. What are the grounds for appeal in partition suit?
Supposing your partition, the shares are not properly quantified, then you can go and appeal. It depends what is your case, how you are asking for partition, under what you are asking for partition. So that way you can put whether order is not properly passed, or maybe if you are saying that it's divided now. Commissioner's report is there where it is divided, it's not properly divided. Then you can challenge that also. So it depends actually on each case.
I just want to know is can a HUF flat be sold without partition of the HUF?
Yes, if all the co-partners and everybody are ready to sign it and give a no objection, it can be sold.
No, assuming that there is a dispute.
No, then it can't be.
Because there's been a matter where the commissioner for taking accounts, there's an order passed by the High Court that the flats have to be sold through the Register of City Civil Court. Commissioner for taking accounts is going ahead with the sale of the flat of an HUF without partitioning the HUF. So that is why this is important.
In that scenario, if an HUF has been, if the court has ordered for sale of HUF flat and this is for taking accounts, I'm assuming the money which will be received, the sale proceeds will be deposited in the court in order to divide between the 3 or 4 of y'all. How many of y'all are there in the HUF is concerned?
Yes. But can it be done without a partition?
Yes, so in that scenario, I told you under the Partition Act only, you can, the court may sometimes order for sale of the flat, and this sale will be under the court orders. So once the sale is done, the amount which is collected, that will be deposited in the court, and the court will then divide between the co-partners.
But what if the HUF has other investments?
HUF has other investments. HUF is not closing down. Understanding from the what you have told me, obviously there could be difference when I.
Would you advise in today's time to form an HUF, or sole proprietorship is a better option?
They are very two different things actually.
Okay.
Now, HUF is something that you taxation purpose you do. Sole proprietorship is more when you do a business. Now, even HUF is also a part of you can have your business, property, etc. in one. But in sole proprietary, again, it's like you have your own property in your own name. And sole propriety is where one person will only do the entire business. So they are two separate things actually. You can't compare HUF with a sole proprietary.
Okay, so HUF is not a dying entity, right? People are
No, not at
you
all.
would
Not
advise.
at all. People do, yes, but yeah, this is better. See, that's why I read a lot of income tax sections, is where the HUF is very good in terms of your taxation is to be taken care of. Of course, you have to see how your family dynamics are and then accordingly decide whether you want to go in for HUF or not. But that actually depends on case to case.